Good morning, everyone. I'm Denise White with Colorado Municipal League. I'm the Communications and Engagement Manager here. And thank you for joining us today, here the first day of session, right, January 8th, as we provide a CML update on the legislative preview for 2025. Today, I have with us the advocacy team here from CML, and Heather Stauffer, our advocacy manager, is going to introduce everybody here in a moment. But before we dive into the meat of the material, I just want to go over a few housekeeping items. We are recording the session as we do, so just want to make sure you're aware of that, and we will post that recording later in this week up on our website so that you can refer back to it or share it with your colleagues if needed. If you're an elected official in attendance today, you will get 1 university credit for being in attendance today to go towards those rewards we give out every year at our annual conference. All participants are on mute today. We do not have you being able to use your own voice in this webinar. We hope you use it on the Hill. But if you need to ask a question or want to chat, you will find they've updated this platform a little bit, but you'll find in that top bar, you see a little chat box or a question box. If you put your question into the question box, I'll be watching for that and make sure that our advocacy team gets that to be able to answer that. And please do, we know that sometimes these, as we're going through these bills, you may have a question on that. You don't want to wait till the end and we have to go back. So please just go ahead and pop those questions in as the question comes to you, and we'll make sure we get to that as real time as we can. With that, I'm going to kick it over to Heather Stauffer, CML's Advocacy and Legislative Manager, and please introduce our advocacy team, and let's get started with the presentation.
Awesome. Thank you, Denise. Well, as Denise mentioned, I'm Heather Stauffer. I'm the Advocacy Manager here at CML. I am joined today by CML's advocacy team, Beverly Stables, Jeremy Schupbach, and Elizabeth Haskell. And we are at the Capitol every single day advocating for municipal interests throughout the legislative session. We're really excited to get back in there January 8th through May 7th, I believe, is the 120-day session. So we will be up there every day advocating for you guys. So I want to just quickly mention a couple of issues that will shape this session, and then we'll get into some specific bills that we're watching. Obviously, this being the first day of the session, they're going to start dropping a whole bunch of bills, and so there will be a lot more to talk about after today. But these are some bills that we know about that we've been working on previous to the session starting. A couple of notes about this session. So the legislature is facing a $6 million deficit. So the budget is going to be controlling everything this session. I believe the Speaker of the House has already said if a bill has a fiscal note attached to it, if it costs the state money, it's dead. So a lot of the bills that we're going to see this session are keeping that in mind and trying to keep out anything that has a fiscal note attached to it. What that means for municipalities is we have to be extra vigilant to look at bills so they're not trying to push that fiscal note down to cities and towns rather than having the state pay for it. So that's one thing that we're going to be watching really, really closely in terms of the fiscal landscape. We have new legislators. We have about 24 new legislators in the General Assembly. A lot of them are going to shape their priorities this session. And so we're going to see a lot of new thoughts, new ideas with those new legislators. Obviously, the House has lost their supermajority, which has implications for what they can do around rules in the House and will shape what the session looks like as well. However, both the House and the Senate, the Democrats have retained the majority. So that's going to shape what we see as well. The Senate obviously has new leadership with President Coleman coming into office, so he will have different priorities as well. So that will shape what we see also. Another aspect of this is the federal actions. So we don't know what that will look like yet, but a lot of legislators are holding bills till they see what the federal, what happens at the federal level. So I think there will be a lot of reactionary legislation. So we'll keep an eye on that. Before we go over all of our bills, just know as things progress, we will be keeping you up to date through our State House report. That report comes out every single week at the beginning of the week during the legislative session, and we'll keep you up to date on bills we're working on, outreach that we need from you, help we need from you, any questions that you have can be answered through our State House report. And you're always, always, always welcome to reach out directly to any one of us regarding legislation. We're more than happy to chat with you about it. So with that, I think we'll start talking about a few bills that we know about. So we want to switch the slide whenever you're ready. Okay, so I'm up first, building code. So we know last session there was a bill around electric fences. This has come up in various iterations in the past, but it essentially defines what an electric fence detection alarm system is. And it reduces the local government's ability to permit these, to deny permits for these electric fences. This is coming from a specific group out of South Carolina that sell electric fences, and they're very upset that some municipalities do not allow electric fences in their community. So this is going to be run by Rep. Soper this year. CML's board in the past has opposed this type of legislation, and we're going to bring it to them again this session to oppose as well and ask for an opposed position as well. But we have not yet taken a position on that, but we do expect that to drop very soon. Next slide, please. Go ahead, Jeremy.
Thanks, Heather. Talking about criminal justice, I wanted to address 4 bills really quick on this slide and the next. These are coming out of an interim committee that has been meeting all summer long to tackle some police misconduct issues that were raised at the end of last session. The first is the prohibition against whistleblower retaliation, and is sponsored by Representative Bacon. This bill is designed to provide a private right of action for an officer who alleges misconduct by another officer or by the department in general in the course of their duty. It allows them to have that private right of action against the department or against another officer and recover damages unless it's frivolous or vexatious or groundless in their claim. Obviously, we have a number of concerns with this bill and the liability that it would potentially put our department and our municipalities under. And we'll be taking a position on this. We just received another draft of this bill this morning and are reviewing that right now. The second bill out of the same task force this summer is the Police Officer Bill of Rights, called the Due Process Bill at the Capitol for political reasons. We have opposed a Police Officer Bill of Rights in 2010 and 2012. It is sponsored by Representative Clifford. And there are ongoing drafting and discussions on this bill. But in short, what this does is provide a number of super protections for law enforcement officers, frontline officers against the department, against the city, against the municipality. It's workforce protections and prohibitions against agency action that really go far beyond any other whistleblower statute, including the healthcare worker statute in Colorado. So that is problematic on a number of fronts. And we know that Representative Clifford is looking at how he's drafted the bill and any changes that he's making, including some by the chiefs. But we do not have a final version of that draft. We have weighted heavily with our concerns so far. Again, as I said, we have opposed in the past, and as it's shaping up right now, we expect to take an opposed or present it to the board for an opposed position if the bill looks as it does in the current draft. Police officer conduct database, also from the same task force this summer and sponsored by Representative Clifford. This is a cleanup of what would put an officer on the post reporting database and therefore ineligible for most law enforcement employment, or what the eligibility criteria for being removed from that same post database would be. For the most part, the legislation looks similar to what's in current statute, with one additional exemption or one additional change, which would require a municipality to turn over records to that officer in order to defend themselves or to make a case for getting off of the database. That if the municipality would fail to turn over those records, the officer would have the ability to sue and subpoena, and if those records are turned over, the municipality would be liable for any court costs relating to that. That is the only new provision in that bill. And we have not seen a final draft of this bill yet. I expect to be having those conversations going forward. Next slide, please, Denise. And finally, a bill brought to us by Aurora, local authorities enforcing vehicle registrations, sponsored by Representative Tone, and our board has taken a support position on this bill. In short, what this bill does is it allows municipal officers to write traffic offenses for failure to register a vehicle or keep timely registration for a vehicle at the municipal level, put it in municipal court rather than sending it to county court. Couple of big benefits for that. When you're a municipality in multiple counties, this clarifies the process of where you go and how you can write that. Two, it simplifies the process for recovering any lost revenue from those fees that the town would otherwise see through the state HUTF and other funds that are collected at the county level and then passed back down to the municipality. And three, it makes public safety and enforcement of timely registration much easier because now officers have another avenue for writing that ticket rather than having to write two tickets, which is the current case because of the county court / municipal court issue. As I said, we support that bill. As of this morning, the Department of Revenue is looking at provisions of the bill that will allow a municipal judge to waive, due to hardship, some of the fees associated or court costs associated with late registration, some of those late fees in a hardship situation. So DOR is looking at the collection and waiver mechanism in that bill. Should expect to see a final version of that shortly. And that concludes criminal justice.
So on the elections front, we just received a draft of this bill. It is one of the first 10 bills that will be introduced this session in the Senate. This is the Colorado Voting Rights Act. And what it does essentially codifies federal Voting Rights Act language at the state level. We're still reviewing it and sending feedback back. However, in our first kind of pass over the draft, we do have some significant concerns around conflict with home rule authority in Article 20 in the Constitution. I mean, the Constitution gives express authority for municipalities to have power over all aspects of their elections. And this bill allows the Attorney General's office to investigate and prosecute complaints related to voting rights acts. So it places the Attorney General's office in a position where they are involved in municipal elections. It also puts us in a position where we are reporting data to the Secretary of State's office that could be eventually used to sue us. So there's a lot of problems with this, and Colorado's legal structure just does not support municipalities being included in this Voting Rights Act. So we're working right now on putting together some feedback for the sponsors to hopefully let them know that municipalities have their own structures for municipal elections, and if they want to target this at the state level, they are more than welcome to do that. That's their prerogative, but municipalities are expressly separate from the state in terms of our municipal elections. We have obviously not taken a position on this, but we'll bring this to our board for a position on that soon. Next slide, please.
Good morning. This one is about gaming. So this is a bill that I just learned about last week, or potential for a bill, and it would allow iGaming statewide. So right now we don't have a board position on it because we haven't been able to take it to the board and we don't have enough details, but it is something that we're watching and hoping to have our voice included and I would say potentially kill. I don't know. It depends on how it comes out. But anyway, we are watching that. And so I know the gaming towns are involved right now and building an opposition to it. And that's all I have on that one.
Okay, so in terms of housing, we are certainly not seeing, at least at this point, the same level of focus and attention on housing and land use as we did last session and the session prior. But still, there's a couple that we want to mention. The first is construction defects. This is coming back again with Representative Byrd. This time she is working with the realtors to push this forward kind of the same players where you have realtors and home builders in favor of this. Our board has taken a support position on this. And then you have the trial bar who is in opposition to it. And they have a lot of influence at the Capitol. So it's a challenge to find language and compromise here that would be useful but would actually pass. So this bill does not include a right to remedy, but it does have third-party affidavits when you're bringing actions. It's going to be a blanket change, so it's not going to be just focused on middle housing, which was something they considered, but it'll go across all housing products. So they're working out a lot of kinks. We've seen an initial draft, and like I said, our board is supportive at this time. We're providing a lot of feedback to hopefully improve this bill. The next one I'll mention is a competing construction defects bill. It's, being, I think, sold as consumer protection oriented, but this would really take us backwards in terms of construction defects and probably further discourage developers from building the types of housing products that we really need. So this one would require construction professionals to provide claimants with a lot of additional plans and information. It broadens the statute of limitations and prohibits higher thresholds than what the state establishes for bringing these claims. We don't have a position on this yet, but we will be taking it to our board. And then the last one I'll mention in housing is a bill related to codes for modular homes. And I'll just clarify that modular homes are different from manufactured housing. Sometimes they are being used, those terms are being used interchangeably, but modular homes are essentially what's being built off-site and brought to the site either to be put together there or some components are already built in the factory. So it's not being built on site. The developers want to have regional codes. That's what this bill would do. It would advise or require a technical advisory committee within the Division of Housing to develop these regional codes. And we have a lot of concerns. Our board has taken an opposed position on this bill, and we are really concerned about the safety component aside from just the preemption issue, ensuring that wind and snow loads are handled properly, what kind of recourse is there if the advisory committee gets these codes wrong. So we're working with the sponsors, but that one is a concern for us. And if you don't mind, Denise, could you go to the next slide, please? So land use, there's a couple here. The first one is coming out of the Cell Phone Connectivity Interim Committee. This is regarding cell phone tower permitting. This would impose a shot clock on municipalities for processing permit applications from telecommunications providers for these wireless facilities, either a brand new facility or substantial changes to existing facilities and towers. And the shot clock, as currently written, is only 60 days. So it's a very short turnaround from when you would receive the application, or actually in the current language, the shot clock could be triggered just from what they call direct communication. That could just be an email. And the shot clock begins if you exceed those 60 days without a decision on the application. It's deemed approved. So there's a lot of issues here. And I'll also mention, we don't have any information from the providers about where this is really an issue in the state. We haven't heard anything about where local governments are taking an inordinate amount of time to process the applications. And in fact, in a lot of cases, local governments are struggling with coverage issues that are not being addressed by these providers. So our board has taken an opposed position on this. And since this is coming out of an interim committee, I expect it to be introduced on the earlier side of session, so please look out for more communication from me. I'd love to do more grassroots advocacy with our members, talking to the sponsors and folks about the concerns on this bill. And along a similar vein, there's a really fun bill called YIGBY. It stands for Yes in God's Backyard. And this is coming from the governor's office as well as the sponsors I have listed here. It would create an administrative approval process for residential development on property that's owned by religious or educational institutions. Our board has taken an opposed position on this one as well. And there's no parameters at this point around affordability of the development, size, density, anything like that. So, you know, in our view, this is a total overreach, certainly is preemption, but at the same time, our question is, why are religious or educational institutions receiving special treatment where they get to bypass our zoning laws and our ordinances and permitting processes that we have in place and have worked hard on? So I'll also be reaching out about this one since it's coming from the governor's office. I think there's a lot more weight behind it, and we have a lot of concerns. So I'll be reaching out likely in the near future with some requests for more advocacy from a grassroots perspective. And the last one I'll mention on land use is relative to mental health transitional living facilities. These facilities were established in a bill in 2023. And essentially what has happened is some folks that have been placed in these facilities, they're residential facilities that are not supervised 24 hours a day. But some of the folks that are being placed in these facilities happen to be registered sex offenders, and the facilities may be located in close proximity to a school or playground or other place where children congregate. So what we are looking to do is codify existing practice from the Department of Human Services, where the department will respect local ordinances when they place folks who are registered sex offenders to ensure that they're not being placed in these facilities right by where children are congregating. So we are working on sponsorships, and we will hopefully have more information in the near future. But this was an issue that occurred in North Glen, but we are running it because it's certainly something that could impact our municipalities on a statewide basis. And we can move on to the next slide.
Great, that takes us to licensing. And I have a couple of bills on licensing to talk about. The first one is a bill that, again, it has not been drafted, and it's coming from food truck vendors. The information I have on this slide actually is slightly incorrect. I hadn't seen the bill, and initially the talk was around more statewide standards for fire and food safety inspections. But I had a chat this morning with the lobbyist for this group, and it looks like the bill is going to focus more on, which I know was another issue, focus more on changing the special events permits issued by DOR, and changing that from 3 vendors, requiring a special events permit if there are 3 vendors, to requiring a special events permit if there are 5 vendors or more. And then they also are expecting to change the way that taxes can be remitted for a special event. And so those vendors that would be remitting to DOR would not have to vendors who are licensed in the municipality as well as with the state and remit through DOR would only need to remit their taxes in their regular tax filing as opposed to also filing a special events filing. And that is because the DOR feels that the special event special remittance form is mostly to catch out of state vendors and stuff. So they're willing to say that these food trucks can file that way and make it easier for them. So that's what the bill looks like. DOR did ask for a $1,000 penalty if someone is not remitting properly on that for that, because they feel like if they're giving them this sort of special treatment, they should at least have a large enough fine to make them do it properly. So we haven't taken it to the board. I don't know exactly what our position will be at, but that's what the food truck bill is. The other bill that we're looking at is the sale of puppies in public places prohibited. So prohibit certain people from selling puppies in parking lots and parks and whatnot. Again, we don't have a position on this bill yet, but what we are looking at is we want to make sure that the bill does not supersede any existing local ordinances addressing the sale of animals in public places. So that's what we'll be watching for that bill. And then the next slide, please. Okay, and then the other bill that I have all these bills that just don't have bills yet, but we have talking about them. So this one is a 4 a.m. bar closing time. This is an issue that was around last year. I've heard this issue's been around actually in Denver for a couple of decades. But what this bill is seeking to do is to allow soft close at 2 or 2:30 and letting bars remain open till 4. We don't have a position on this, wanting to make sure mostly our concern right now is that municipalities have the option to opt into this provision as opposed to having to opt out of it. And so if a town decides that it's beneficial for them to have this provision on their books, that they can do that, but we don't want to have to try and opt out of a statewide provision. And just stay tuned on that one. So next slide.
Thanks, Elizabeth. A couple of bills related to municipal court operations I want to discuss really quickly. The first is our CML sponsored and initiated legislation this year, which is regarding PR bonds and FTA, which are failures to appear. We have noticed and tracking a municipal concern around public safety, retail theft, trespass, and municipal ordinances, where some individuals have frequently begun to take advantage of the PR bond statute requirements that would give them a PR bond and are not able to hold with a cash bond or a surety bond. And this creates obviously a public concern for us. The bill is intended to allow a municipal court the discretion to, after a certain number of failures to appear or PR bond violations, issue a cash or surety bond to that individual, which allows us to, one, address the underlying issue and push them through the court system and take care of the case. And two, in cases where there's appropriate other resources, to use diversion or other community resources to help those individuals and to provide them in other forms of assistance. As drafted, the bill requires would trigger the ability for a surety bond or a cash bond after 5 failures to appear or PR bond violations in 2 years. And so far we have bipartisan sponsorship on that bill. We have had great conversations both with legislatures on both sides of the aisle, as well as some advocacy groups. We do expect this to be a tricky bill to pass, but given the next bill that I'm going to discuss, addressing this and giving municipal courts a tool to address these frequent and willful violations of PR bonds and failures to appear where people just have chosen not to show up and make a habit of doing it, a really important tool. The next bill, which prohibits an ordinance around making failure to appear a contempt of court issue and thus a jailable offense as a separate offense brought by the ACLU, sponsored by Senator Weissman, Henderson, and Representative Carter. CML will take a position on this bill when we have seen language for it. We have not yet seen the language, but the bill is intended to prohibit municipalities, including home rule municipalities, from drafting an ordinance that would make failure to appear a contempt of court issue that is a jailable offense as a separate issue. It tries to draw a line between the court's ability to issue contempt for traditional means and prohibit a municipality from making failure to appear a contempt of court issue. There are about 13 or 14 municipalities that have that as an ordinance right now. And so the other thing that the bill will do is prohibit a court from jailing someone for failure to appear. So it is very analogous to the problems addressed in our PR bond statute. And we're looking forward to the discussions on both of those on that entire issue. The third bill addressing municipal courts this year is Municipal Court Transparency and Reform by Representative Mabry and Senator Weissman. This bill has three aspects to it. The first is to require and shore up the right of someone in municipal court who faces incarceration, their right to a defense counsel at the time of their hearing. Second thing the bill does is require and prohibit municipal courts, require municipal courts to follow state sentencing guidelines and prohibit municipal courts from any sentence that would be longer than an analogous statewide sentence. So primarily limiting to 10 days on all offenses or at the most. And then the third thing the bill does, and I should mention we have not seen a draft, but the third thing that we understand the bill does is take increased efforts at courtroom transparency. Believe that this is looking at ensuring that any hearing that a court would hold where someone is facing incarceration or currently incarcerated, that they would have public access to that hearing or a video monitor of that feed. Again, waiting on final legislation. We're talking to those advocacy organizations that are bringing that forward, and looking forward to a conversation with Representative Mabry and Senator Weissman on it. It's an ongoing conversation from us. Obviously, when we see the legislation, this will go to our board for a recommendation. In short, we're very, very concerned with the limitations the bill intends to put on municipal sentencing guidelines. Believe that there's a number of reasons that one, it's premature. The Supreme Court is looking at those issues right now, and we need to let the Supreme Court of Colorado play out and review that case. So it's not time to talk about it. And two, there are home rule and other reasons that a municipality needs its own independent sentencing guidelines, and just aligning them with the state for the sake of convenience is not good public policy. So we continue to watch that and are encouraging representatives and advocacy to wait on that particular piece of the legislation until the Supreme Court weighs in. So that takes care of this slide.
All right, let's talk a little bit about municipal liability. We know that a rewrite of the Colorado Anti-Discrimination Act is coming. This bill is coming out of the Task Force for the Rights of Coloradoans with Disabilities. It was one of their recommendations was around the rewrite of the Colorado Anti-Discrimination Act. We have not seen a draft of that, so we don't know how extensive the bill will be. However, the recommendations that were made included removing remedy requirements, amending statutes of limitations to increase the statute of limitations around discriminatory claims, recovery of additional punitive damages, and removing limits on damages for discrimination, and then also recovery of damages for emotional distress. So those types of issues coming up in this legislation is very problematic for public entities. We know that removing statutes of limitations, increasing our liability, makes it harder for us to get insurance, makes it harder for us to provide services on the public level. I think that we will see concerns not only from municipalities, but also probably from the business community, also from the state around removing remedy requirements and some of these recommendations if they do make it into a bill. We just don't know how extensive that or how far that bill will go. So it is something that we're watching, waiting for a draft. Next slide, please. Open meetings and open records. So the first bill I want to talk about, this is the Public Records CORA bill. Senator Kipp now is running this bill. It's very similar to a bill that she ran last session in the House. It gives additional time for responding to CORA requests to clerks or records custodians, and it moves that from 3 to 5 days to, changes that from 3 to 5 days, and it changes those record request timelines to 7 to 10 days for extenuating circumstances. It also adds provisions that if a custodian is not scheduled to work during that time period, that is considered an extenuating circumstance in which you can take more time for. We're working out language around pecuniary gain requests. So a lot of times businesses will request CORA, make CORA requests around to get information for their business. There's language in the draft right now that would give us about 30 days to respond to those. Obviously, some business groups are pushing back on that, on who gets to decide if it's a record for pecuniary gain. So we're working that out right now. Notably, I will say a difference from the last iteration of this bill from the House is that it does not have vexatious requester language. So last year there was a provision that said vexatious requesters, so your requesters who purposely file multiple CORA requests in order to kind of stop the business of government. It would have allowed clerks and records custodians to take longer in responding to those vexatious requesters. They found that it was too hard to get across the line with the media and other entities, so they have removed that vexatious requester language from last year. We will take this new iteration of the bill once it's finalized to the board, and we did support this bill last year. I'll mention accessible public meetings. This is also a bill that came up last session that I expect to resurface this year. It made requirements around using video conferencing or audio conferencing for public meetings, amongst other requirements. So we have not seen a draft of that bill either, but we do know that it's coming back. They may change this a little bit to have those requirements be upon request. We have yet to see, but that will change a little bit, I believe, this year. Typically, that bill has been stopped in the last few years by a fiscal note by the state. So we'll see if that continues as well. Next slide, please.
Okay, transportation. So I think originally, like at the end of last session, there was a lot more enthusiasm maybe for broader transit reform, but in light of the realities of the budget that Heather mentioned earlier, I don't know what we'll really see in terms of sweeping changes or reform around transit. Some that we know of are here on this slide. These are all coming from the Transportation Legislation Review Committee, which is an interim committee. So there could be other significant pieces of legislation. We just don't know about them yet. So the first one I'll mention has to do with mode choice plans. So mode choice just refers to the way in which someone gets from essentially like A to B. So whether it be single occupancy vehicle, public transit in whichever form that takes, bicycling, walking, etc. And what this bill would do is require local governments with populations over 25,000 to create mode choice implementation plans every 5 years, essentially reporting to the state on what, percentage of trips they would like to be completed via carpooling versus public transit, and have those goals be implemented in the municipality's transportation planning. And then it would also require those local governments to report to the Energy Office on what the projected emissions reductions will be. So our board took an opposed position on this bill, and our feeling is that this type of work is something that CDOT and the Energy Office can already be engaging in, especially with their role in public transit across the state. And especially when it comes to the budget shortfall that we're expecting, we want to be really sensitive to the types of unfunded mandates that are being pushed on local governments. So those are our concerns there. And then another one that we took a support position on from our board is local funding for vulnerable road user protection. Vulnerable road users just refer to pedestrians and bicyclists, essentially. And there was a different version of this bill that came up last session that would have put fees on all vehicles above a certain weight across the state. What they're doing this time around is having it be essentially an opt-in program. So local governments would be able to impose an additional fee on certain vehicles of their choosing, and they come up with their own fee structure, report it to the Department of Revenue, and are able to collect funding that can then be used for these vulnerable road user protection projects. So things like barriers and cycling lanes, things like that. I think I mentioned already, but this is one that our board has moved to support. And then the last one I'll mention in transportation is relative to paratransit services. So services for folks with disabilities that are like parallel to your other transportation services that your local government offers. It would require local governments that already offer these specific paratransit services to create plans for how they're going to provide these services during an emergency, ensure parity with paratransit fare collection, and then possibly the most impactful would be local governments would be required to consult with affected members of the community before they reduce any of these paratransit services. Our board has taken a monitor position on this one, but we are watching it very closely. There's actually not that many local governments that we have heard from who offer these services. Those that do, oftentimes, a lot of the mountain communities do. But like I said, we're monitoring this one. We're watching it very closely. And we can move on to the next slide.
Before we move on to the next slide, Bev, can you just clarify on the increased transportation mode choice? Our board position says amend, and you mentioned that we're opposed. Is that?
Oh, I apologize.
An amend position?
It is an amend position. I apologize. Yes.
No worries. Just wanted to clarify. Thank you.
It's right there. Sorry.
Next slide, please. So I'll mention a couple notes about severance tax in particular. The future of severance tax and water. This was brought up during the water interim committee, and so it will pass out of the interim committee, so it will be one of the first few bills coming out. It creates a task force in the Department of Natural Resources to study the future of water funding and severance tax. As we know, severance tax is a very volatile tax, and it's going to make recommendations on a path forward, specifically around water projects and water funding in Colorado. We are supporting that bill, and we have asked the sponsor to amend the bill to increase the scope from just studying the Department of Natural Resources side of severance tax to including the Department of Local Affairs severance tax in that as well, because that is the piece of it that impacts local governments the most. I'll also mention that the governor's budget proposal that came out in the interim included a proposed sweep of $20 million over 2 years from the Energy and Mineral Impact Grant Fund. As we know, that fund is used to fund a variety of projects in local governments that are energy impacted. so we would hate to see that money being swept into the general fund for pet projects. We do think that those local government projects, which oftentimes include water and wastewater projects, should be held to a higher standard and protected within that. So we are going to fight hard against that sweep and keeping that fund for local governments. We can move on to the next slide, please.
And that's over to me, and I've got a few bills that I'm monitoring and moving forward as CML initiated legislation under taxation. The first bill is a bill that would enable statutory municipalities and counties to seek voter approval to implement excise taxes. This bill is CML initiated legislation. The Colorado Association of Ski Towns had proposed the idea, and as well as the Colorado Counties Incorporated have put it on their legislative priority list as well. So we're working in conjunction with those two organizations to push forward this bill that would, like I said, allow municipalities and counties to ask voters for excise tax. Right now, the sponsors are the Speaker and Senator Roberts. Our board took a support position on the bill, obviously, and and we are right now in a little bit of a holding pattern on the bill, and it will not be introduced right away, but we're hopeful that it will get introduced in the coming weeks and will be successful. So that's one bill. The other bill, I'm going to skip over third-party auditor for a minute. The other bill that is a CML initiated legislation is a vacancy tax bill, which would again permit local government municipalities and counties to go to the voters to ask for the implementation of a vacancy tax. Right now, we are still discussing this. We don't have a bill draft. We are working with the Speaker on the how this bill would look, possibilities of it passing, and making lots of decisions about it. But we are still talking about it, and hopefully we'll start getting something on paper in the next, I'd say, next month or so. So this bill, we're hoping will come forward, but it would be much later in the session. So if anybody has questions about that, I'd be happy to discuss that with you offline. Back up to the third-party auditor confidentiality bill. This is a bill that came out of the Sales and Use Tax Simplification Task Force, and it's simply reiterating that third-party auditors are bound to the same confidentiality standards as municipal tax offices when conducting a sales tax audit, and we support that. Initially, that bill, Simplify Colorado was trying to require third-party auditors to sign non-disclosure agreements, and we just prefer to reiterate that they're responsible for the same confidentiality as municipalities. And then the final bill that I have on the taxation is, and you can't see it here because somehow we got it a little bit messed up, but it's the Assessors Metro District Bill. This is a bill coming out of the Assessors Association, and basically what they're looking to do here is fix a loophole related to metro districts that receive a property tax exemption when sort of in a way that the assessors aren't really pleased with. And basically it would be someone who owns property in the metro district leases the property to the metro district, and then the metro district would lease that property back to a private vendor or owner, and the property tax, there's no property tax on that property. So they're working on that. We don't have a board position on that yet. We have looked at the initial draft and made some suggestions to make sure that municipalities are not being harmed by this bill. So anyway, that takes us to the next slide, I guess. All right, and then the final slide is urban renewal authorities. And I just found out during this meeting that this bill has been pulled and will not be going forward. So we're very excited about that. We did some communication with the governor's office. We spoke to some other players in this area, this was a Colorado Counties Incorporated bill, initiated legislation. I did some talking with them, and the sponsor apparently has decided not to go forward with this bill at this time. And it would have been very similar. Senator Marchman was going to be the sponsor. And it would have been very similar to her bill back in 2023 that would have eliminated the exemption for ag land prior to 2010 being moved or included in a new URA. So we're very pleased that the people saw it our way. And anyway, so I'm happy about that. And I don't know, back to Heather maybe to close it out.
We do have just one more slide around water, so I'll mention that.
Oh,
but
I'm so sorry.
You
seemed like
I'll just mention that the best opposed bills are bills that never happen. So congrats, Elizabeth. That's great news. Just one bill on water. We're not seeing a lot on water this session. Backflow prevention device requirements. So a little background on this. This is coming out of House Bill 1344 from last year, was the sunset of the plumbing industry regulation. And they the union snuck a little language in there that required anyone inspecting and working on backflow prevention devices to be licensed through the Department of Regulatory Agencies. So very specific licensure requirement from there, required to be a plumbing occupational licensure, I should say. So that severely limited the amount of plumbers that were available to inspect these backflow prevention devices. And we know that backflow prevention prohibits cross-contamination from water and drinking water and wastewater. So it's very, very important that these backflow prevention devices are properly inspected frequently. So this bill reverses that action that was taken in House Bill 1344 last year, and says the inspection, testing, and repair of backflow prevention devices does not require a plumbing occupational licensure from DORA. So that's good news for municipalities, for municipal water systems that inspect these devices. And we'll be taking that to our board to ask for a support position on that as well. And that's it.
Great. Now I'm going to come back in. We have not seen any questions at this point in time, so I just want to encourage anybody, if you do have questions, we have just a couple minutes left here, but you also know how to reach us at CML should questions come up. As I think we've mentioned before, please sign up for the State House report so you get kind of weekly updates on what's going on. Visit our advocacy page on cml.org. We're whipping that into shape for a session as well, and we'll be having the bill tracker as well as position papers as they become available. Be getting those out to you. Anything else you want to tag on to that with, Heather?
I'll just mention that grassroots advocacy is one of the most important things that we can do for our communities. And so we're more than happy at any point of time, if you want to be involved in the process, if you want to come to testify at the Capitol on an issue that affects your community, we can help coach you through testimony. We can accompany you to the Capitol. We are happy to help in any way that we can. But your voice is incredibly effective when we're talking to legislators, because they want to hear from people in their community. So I can't emphasize enough how important it is for each of us to be involved in the process. They hear from us every single day, all the time, but hearing from you adds another level to it. So any way we can be helpful on that front to get you involved, we'd be more than happy to assist.
Great, thanks. It really is a tag team effort, right? We do our part and we get them involved too. So I think That would be it. So I just want to say thank you to all of you, Bev, Jeremy, Elizabeth, and Heather for coming today. I know it's the first day of session, so it can get busy. So appreciate you taking time to spend with our members and let them to know what's coming up and what to be prepared for. And for all of our members, thank you for joining us today as well. We know days get busy, so appreciate you choosing to spend some time with us. Again, we will get a recording up on our website with this information that you can share with colleagues who maybe weren't able to attend. We do plan to also kind of, as we have in the past, do like a mid-session update and then a closeout at the end. So we'll have more opportunities to discuss what's going on. And with that, I just want to say thank you for everybody, and we'll send you on your way for a great day.